British Employment Tribunal presidents report emergency application surges across regional offices. That surge began because self-represented litigants started using free artificial intelligence tools for tribunal filings. Supporters want filing restrictions to prevent backlog delays, while critics say bans hurt unrepresented citizens. Should courts restrict AI-generated lawsuits? What's your opinion? Restrict automated legal filings or protect low-cost access for people without lawyers? British employment tribunals historically received around 20 emergency interim relief applications per year nationwide. But applications recently surged to about 20 per month across each of 12 regional offices. Overall employment claims rose 39% to 50,000 in the year to March 2026. Complex discrimination cases also expanded from 33% of court dockets to 61%. Meanwhile, bar rules already punish licensed lawyers who submit unverified artificial intelligence citations. Tom, are court restrictions now essential to keep judicial schedules moving?
Yes, David. Courts must act because automated tools are burying tribunal schedules under massive delays. Regional tribunal memos link free software to a reported 100-fold surge in emergency applications. Looking at the numbers, unresolved backlogs grew 55% to 64,000 cases. That backlog means some employment hearing dates now stretch into the year 2030. International bodies face identical problems from automated filing tools. A Dutch municipality saw a 400% increase in property tax valuation appeals. Researchers have documented 93 similar filing spikes across 11 different countries. Automated legal drafting also corrupts court records with fake case citations and multi-hundred-page pleadings. Judges spend precious hours sifting through repetitive scattergun claims that lack real merit. Existing ethics rules punish licensed attorneys who submit fake artificial intelligence citations. However, self-represented litigants are not bound by professional bar association rules. Targeted filing restrictions are essential to protect judicial accuracy and stop multi-year court delays.
Tom argues that unrestricted artificial intelligence filings overwhelm tribunals and compromise court record quality. He stresses that lawyer rules cannot stop unrepresented users from flooding dockets with weak claims. Emily, how do you respond to these warning signs about system backlog?
David, restricting these tools creates unfair financial barriers for citizens who cannot afford expensive lawyers. Free artificial intelligence software lets self-represented workers draft employment claims at very low cost. Unrepresented litigants can now submit emergency interim relief applications without paying high billable hours. That access keeps employment courts open to everyone. What we must remember is the argument that mounting tribunal delays stem from wider legal changes. Government expansions of statutory worker rights have increased case volumes across the entire tribunal system. Chronic underfunding of judicial staff created long hearing delays long before artificial intelligence appeared. Technology bans simply punish vulnerable citizens while leaving the root causes of backlogs unaddressed. Furthermore, courts already possess robust procedural checks to handle poor or unverified submissions. Judges actively enforce ethical sanctions and summary dismissal powers against any improper filing. We do not need heavy administrative bans when traditional judicial rules already protect court integrity.
Emily contends that technology bans lock out ordinary citizens who rely on low-cost software. She asserts that court backlogs come from underfunding, while existing judge powers handle weak submissions. Tom, how do you address the concern that restrictions harm unrepresented litigants?
That risk is real, but free software also creates a dangerous cost imbalance for court respondents. I agree that free software significantly lowers initial drafting costs for people without human legal counsel. But zero drafting costs allow users to launch complex legal battles at almost no personal expense. Platforms like Objector AI generate detailed planning objections for just £45. Responding businesses and public councils must then pay high billable hours to review each submission. Small employers spend thousands of pounds just reading multi-page automated claims. Courts become congested when responding sides cannot clear papers quickly. This unfair asymmetry weaponizes court procedure and destroys timely access for legitimate cases. Filing rules restore balance to the system.
Tom grants that artificial intelligence lowers user fees, but warns of heavy financial pressure on respondents. He argues that cheap automated claims force responding businesses into massive billable legal expenses. Emily, can courts handle these automated filing volumes without blocking legal software entirely?
I acknowledge that emergency tribunal filings have surged, creating real administrative pressure on staff. Hearing delays are a genuine concern for every applicant waiting for justice. However, banning technology is the wrong answer to backlog growth. Yet artificial intelligence submissions often provide far better structure than disorganised handwritten notes. Senior Judge Sir Geoffrey Voss noted, "Automated filings are clearer than carrier bags of loose papers. Structured headings help judges evaluate essential claim facts much faster." Specialised software also reduces administrative sludge by organising complex rules. It transforms confusing legal jargon into readable summary sections. Instead of banning digital tools, courts should enforce strict page limits on every filing. Standardised pleading templates can easily stop multi-hundred-page document bloat. These templates keep documents concise without locking people out. Smart procedural rules protect court schedules while keeping justice accessible for unrepresented citizens.
Returning to today's tribunal surge, this debate highlights a central conflict in modern legal systems. The deciding question is whether courts should restrict automated filings to protect tribunal efficiency, or should they preserve these tools to ensure affordable legal help for unrepresented citizens. Both sides raise essential points about fairness, administrative speed, and equal justice. Relevant legal precedents show how digital tools can operate alongside human representation. In an English court trial, Garfield AI recovered £7,000 in unpaid fees for a freelancer. Software generated all necessary court filings, while a human barrister managed oral trial advocacy. That hybrid approach combined affordable drafting with professional human court oversight. One clear test will emerge over the next 6 months. We must watch whether employment tribunal backlogs decrease after introducing preliminary filing verification screenings. That test will show if screening reduces delays without stopping self-represented litigants from filing claims. It will prove whether preliminary checks can protect court dockets. Now it is your turn to practice 3 useful debate expressions from today's discussion. First, to introduce supporting data, use looking at the numbers. Looking at the numbers, court backlogs increased by 50%. Looking at the numbers, free legal software serves thousands of users. Looking at the numbers, emergency filing applications quadrupled this year. Next, to highlight a key argument, use what we must remember is What we must remember is that court funding remains severely limited. What we must remember is who bears the burden of long delays. What we must remember is that unrepresented litigants need fair legal access. Finally, to grant a point before replying, use that risk is real, but court rules can prevent filing abuse. That risk is real, but software helps people without private lawyers. That risk is real, but complete tech bans create unfair barriers. Try using one of today's debate expressions in the comments below. Thank you for watching The Breakfast Debate on English Breakfast Club, and goodbye until next time.